So welcome, thank you for joining us today. My name is Abigail Brightwell, I'm a partner in the employment team here at Brachers, and I'm joined today by my colleague Monikar, who is a solicitor in the employment team. Now, just to give you an overview of today's session, there have been a number of changes in recent years in respect of different family-related leave entitlements, and so the purposes of today is that we're going to have a look at an overview of where we are currently at in terms of current family leave entitlements, highlighting where there have been some recent changes. Monika is then going to have a look at some of the proposals under the Employment Rights Bill and when we might see some of those changes coming into force. And I'm then going to touch on the recently launched government review into the entire parental leave landscape and what this could potentially mean for the future and what, if any, steps employers need to be taking now to get prepared. So I'm going to start with having a look at where we are in terms of current entitlements. And I've set out on the slide a summary of some of the family-related statutory leave entitlements which are available to employees. Now, I'm not proposing to go into a huge amount of detail on all of these, as I'm sure as employers and organisations you will be well aware of these entitlements and how they operate. This is an area, however, where things do change and these entitlements do become more enhanced, and it can sometimes, we appreciate, be hard to keep up to date of the latest position. So I'm going to pull out some of the areas where there have been some changes and those areas where you may be a little bit less familiar with. So starting off by looking at maternity leave, and most of you will be, I'm sure, comfortable with the current regime in terms of entitlements to maternity leave and pay. Now, we're not expecting to see significant changes to the maternity leave and pay. We don't believe these are currently proposed. And as you will no doubt be aware, all pregnant employees, regardless of their length of service, are entitled to 52 weeks statutory maternity leave, which consists of 26 weeks ordinary and 26 weeks additional maternity leave. In order to take it, employees must provide appropriate notifications, and during this leave, employees continue to benefit from all of their existing terms and conditions of employment, aside from those in relation to remuneration. And in addition, they may be entitled to receive statutory maternity pay where the relevant conditions are met. Now, employees have a right to return to the same job on the same terms and conditions after taking a period of maternity leave, or in some cases to a suitable alternative job. Now, something I did want to highlight in relation to maternity leave was some changes which came into force on the 6th of April 2024 in relation to some increased entitlements or protections in relation to redundancy for pregnant employees and for those who are on maternity leave. And what these reforms last year did was extend the protection from redundancy for a longer period. So the protection now extends to employees who are pregnant from the date that they inform their employer of their pregnancy and for the full period of the pregnancy. And in addition, that enhancement was extended to employees on maternity leave who are now protected for a longer period of 18 months from the first day of the estimated week of childbirth, rather than just the period of their absence on maternity leave only. And during this extended period of protection, if a redundancy situation arises, pregnant employees and those who've returned to work from maternity leave will have priority during that protected period for any suitable alternative roles. So this is an important one to bear in mind, as we appreciate, given the longer nature of the extended period, it is something that could potentially be overlooked if you are carrying out a redundancy exercise. Moving on now to have a look at paternity leave, and this is an area where we are expecting to see some fairly significant changes under the Employment Rights Bill, which Monika will go on to have a look at. As the law currently stands, eligible employees are entitled to take up to 2 weeks paternity leave, which should be taken generally within 52 weeks of the child's birth or placement for adoption in adoption cases. And the entitlement extends to employees, not other workers, and it's available to both men and women where they are the parent of the child or the spouse, partner or civil partner of the child's mother or adopter, and it's subject to satisfying a number of conditions which we have set out on the slide. So the entitlement can apply to the child's natural father, the natural mother's husband, civil partner or partner of either sex, also to an adoptive parent of either sex or a foster parent under a fostering for adoption arrangement who is not otherwise taking statutory adoption leave, or an intended parent under a surrogacy arrangement who again is not taking adoption leave. And one of the other conditions that has to be satisfied is that the employee must have or must expect to have responsibility for the child's upbringing. And if they're not the natural father, then they must have or expect to have the main responsibility along with the child's mother or their co-adopter for the child's upbringing. And if they satisfy those criteria, then they can take the paternity leave, but there is a qualifying service condition, and they must have 26 weeks qualifying service, so not currently a day one right. As I mentioned, the purpose of taking the leave is in order to care or support the mother or adopter in the caring for the child. And there are, again, notice requirements which will need to be complied with. Now, those reduced, so from April 2024, the period of notification reduced from 15 weeks down to 4 weeks. In terms of how much time off can be taken under this right, employees are entitled to take up to 2 weeks paternity leave, and they can choose to take that leave either as a single period of 1 or 2 weeks leave, or 2 non-consecutive periods of leave of 1 week each. Again, this changed in April 2024. Before that, the leave all had to be taken in one block. There is a right to payment if qualifying conditions and criteria are satisfied. And as I mentioned, this is an area where we are expecting to see some changes proposed under the Employment Rights Bill, which Monika will go on to have a look at. Now, I'm not proposing to look at current entitlements in respect of adoption leave in great detail, and we have put out some information on the slide. In summary, statutory adoption leave is available for the duration of 52 weeks in total, consisting, similar to the maternity leave regime, of 26 weeks ordinary adoption leave and 26 weeks additional adoption leave. It's available from day one of employment for employees who are adopting through an approved agency or via a surrogacy arrangement. And only one parent in a couple can take adoption leave. The other may be eligible for paternity leave or shared parental leave. As I mentioned, this works in a very similar way in terms of the notification and eligibility criteria to statutory maternity leave. And the same extended protections from redundancy, which I mentioned earlier, also apply to employees who are returning from taking a period of adoption leave. So again, it's one which is worth remembering, keeping on the radar if you are carrying out a redundancy exercise, to make sure that you have caught all those within that protected period within that. And similar to maternity leave, this isn't an area where we are currently expecting to see a huge overhaul of changes under the Employment Rights Bill. Now, shared parental leave is an area where we think we are likely in the future to see some possibly significant changes. As the law currently stands, shared parental leave allows eligible parents to share a period of up to 50 weeks leave and 37 weeks of pay following the birth or adoption of a child. Now, the intention behind shared parental leave is to provide some flexibility for both parents to take time off of work either together or separately in blocks or all at once. However, in practice, it's quite complicated in terms of the arrangements for taking it, and generally speaking, the uptake does seem to be quite low. Very briefly, how it works is that it must be taken within the first year after the child is born or placed for adoption in adoption cases. And that period of 50 weeks of leave can be split into up to 3-week blocks per parent with periods of work in between. Parents can decide how they want to divide the leave and pay between them, and notice must be given to the employer. And curtailment notice must be served in order to bring a period of maternity leave or adoption leave to an end. And eligibility evidence, again, must be provided to the employer in order to share the balance of that leave with the other parent. As I mentioned, in practice, the uptake of shared parental leave is fairly low, and in part this can be attributed to some of the complex notification processes. So the government is piloting some digital tools in order to make shared parental leave easier to manage and apply for, because as I say, this is a potential barrier to its uptake. And as we're going to have a look at a bit later on, this is an area where we may see some change under the government's proposals. I've referenced on the slide parental leave, which is a statutory parental leave to unpaid time off of work that eligible employees can take in order to care for a child. It's a completely separate right to maternity, paternity, adoption and shared parental leaves. And there are some eligibility requirements which have to be satisfied at the time that the leave is taken, which are that the employee must have been continuously employed for at least a year, unless the child's entitled to a disability living allowance. They must have parental responsibility for the child. The leave must be being taken for the purposes of caring for a child, and it must be taken prior to the child's 18th birthday. In terms of the entitlement itself, it's up to 18 weeks of unpaid leave per qualifying child, with a maximum of 4 weeks leave that can be taken per year in weekly blocks, unless the child is entitled to a disability living allowance, in which case the weekly blocks criteria doesn't apply. There's nothing to stop employers and employees agreeing to more flexible arrangements, but the default under the statutory regime is that 21 days notice must be given of entitlement to take the leave, and an employer can, for legitimate business reasons, postpone the taking of that leave. Now, the statutory right is that it is unpaid, so unless you agree otherwise contractually, no pay or benefits would be payable during a period of parental leave. And again, we are seeing some proposed changes to that under the Employment Rights Bill, which we'll go on to have a look at shortly. Now, this year we saw the introduction of statutory neonatal care leave and pay. Prior to the 6th of April this year, there was no dedicated right to leave or pay for parents whose babies required specialist neonatal care after birth. And in those circumstances, employees would be required to use other types of statutory leave or holiday, which aren't really intended to cover long hospital stays. So against that backdrop, this leave came into force with effect from the 6th of April this year. And it's a day one right, so it applies from the first day of employment, and it's in addition to other leave entitlements that employees may be entitled to take, such as maternity, adoption or shared parental leave. Now, it applies to the parents of babies who are admitted to neonatal care up to 28 days old, and eligible parents can take the leave once their child has been receiving neonatal care for at least 7 consecutive days. It doesn't necessarily mean in hospital. It can include medical care under the direction of a consultant after the child has been discharged from hospital. The purpose of the leave is that it must be taken in order to provide care for the baby, and in the sad circumstances where the baby dies after the right to take the leave has accrued, eligible parents are still able to take the leave. Now, in terms of how much leave, eligible parents can take a week's leave for each week that the baby receives neonatal care without interruption, up to a maximum of 12 weeks, which again has to be taken in weekly blocks. It must be taken within 68 weeks of the baby's birth or placement in adoption cases. And in practical terms, in many cases, the employee will already be taking another type of leave, likely at the time that the baby is receiving neonatal care. For example, they might be exercising their right to take maternity leave. Now, in those cases, the neonatal care leave isn't lost, and it is essentially tagged on to the end of the employee's family leave, and that's known in the regulations as taking Tier 2 leave, and that has to be taken in one continuous block. Now, if the employee is not already taking some other form of family leave when the baby receives the neonatal care, then the employee can take what's termed as Tier 1 leave, and that's likely to apply in circumstances, for example, where a father or partner's paternity leave has run out while the baby is still receiving the neonatal care, and that Tier 1 leave can be taken in non-continuous blocks of a week at a time. There are again some notice and requirements that employees must satisfy in order to take the leave, and there is an additional right to statutory neonatal care pay on top, which is paid at the same rate as statutory paternity pay. Again, this is subject to eligibility requirements, including a 26 weeks continuous service requirement, and the maximum pay available is 12 weeks pay. Now, there's some helpful guidance that ACAS have produced in relation to this new right. It's worth having a review. We've put a link to it on the slides, and essentially ACAS recommends that employers act sensitively and with flexibility when dealing with these requests. Now, finally, I wanted to just give you a reminder of the statutory entitlement to parental bereavement leave, which is a leave available to employees. There's no length of service qualification, and the right is to 1 or 2 weeks off work on the death of a child, including a stillbirth after 24 weeks of pregnancy. Now, this leave can be taken any time in the 56 weeks following the death of a child, and it's paid at a statutory rate, again subject to satisfying qualifying conditions, which include a 26 weeks service requirement. It's worth reminding you as well that there is in development a bereaved partner's paternity leave, which will be unpaid, which is currently, as I say, in development, and the government has stated that it aims to bring this entitlement into force in 2026, although we don't currently have a date set yet for when that will be introduced. But again, it's something to have in mind that is likely to be coming in next year. I'm now going to hand over to Monikar, who is going to have a look at some of the proposed changes under the Employment Rights Bill.
Thank you, Abby. So let's look at 2 significant reforms under the Employment Rights Bill that will directly impact family leave entitlements from April 2026. So, like Abigail said, currently statutory paternity leave requires 26 weeks of continuous service. This is anticipated to change. So under the new legislation, paternity leave will become a day 1 right, meaning employees will be eligible from the very first day of employment, and so no qualifying period will be required. And this would apply to biological fathers, adoptive parents, civil or unmarried partners. And this is expected to come into force in April 2026, allowing time to update policies and systems accordingly. Furthermore, parental leave. So similarly, unpaid parental leave currently requires 1 year of service, and this will also is anticipated to become a day 1 right. So this would align with parental leave, maternity, adoption, and now paternity leave, creating more of a consistent framework. Employees will be able to take up to 18 weeks of unpaid leaves per child up to their 18th birthday from the start of their employment. And again, this is a reform that's currently scheduled to take effect in April 2026. Let's now turn to the proposed changes around bereavement leave, particularly in relation to pregnancy loss and broader bereavement situations. So under current law, statutory bereavement leave is only available for child deaths under 18 or stillbirths after 24 weeks. The Employment Rights Bill introduces a new entitlement for those experiencing pregnancy loss before 24 weeks, including miscarriage and IVF loss. This will be a day one right, offering at least 1 week of unpaid leave to both the individual and their partner. The change is part of a wider effort to support grieving families and reduce the stigma around early pregnancy loss. The planned implementation date is 2027, following further consultation. Furthermore, bereavement leave. The bill also expands bereavement leave to apply more broadly than on the loss of a child, introducing a new day one right, at least 1 week of leave following the loss of other loved ones. Exactly who this will include will be set out in the regulations, although we anticipate spouses, parents and siblings would be covered. This will be a day one right for eligible employees, offering 1 week of unpaid protected leave per bereavement. Statutory pay will continue to apply only in cases of child death or stillbirth. Again, implementation is expected in 2027, subject to consultation. Finally, let's look at the strength of protections for pregnant employees and new mothers under the bill. Current law at present, employees who are pregnant or maternity leave or within 18 months of childbirth have priority for suitable alternative roles in redundancy situations. From 2027, it is planned to become unlawful to dismiss pregnant employees or new mothers within 6 months of returning to work, except in specific circumstances such as gross misconduct. This protection will apply to all types of dismissal, not just redundancy. The aim is to reduce maternity-related discrimination and improve job security for women returning to work. Protections may also be extended to those returning from adoption leave, shared parental leave and other statutory family leave, subject to consultation. Again, the implementation of this is expected in 2027. So these changes are significantly raise the bar for lawful dismissal decisions involving pregnant employees and new mothers. So employers should prepare by reviewing their dismissal procedures and training managers on the anticipated changes. So I'll pass this back to Abigail to talk about the consultation.
Thank you. So in amongst all these proposals for change, which I'd say are anticipated to come into force in the next couple of years, we've also had in July this year the government launching what's been they've dubbed the landmark review of parental leave and pay. So as I say, it was launched on the 1st of July this year, and it is an 18-month review into the current parental leave landscape. It started with an initial public call for evidence, which recently closed, and I have set out on the slide a link to the relevant paper if you wanted to go and have a look. Now, essentially, this has come about and in order to aim to modernise the system in the UK to better support working families and align with the needs of today's economy. Essentially, there was a report published in June this year which stated that the statutory parental leave system in the UK doesn't support working families and has fallen far behind most comparable countries. Now, the review sits within the government's wider plan to make work pay, by which the government is aiming to drive economic growth alongside better living standards for working families. Now, I've set out the stated objectives from the review on the slide, and overall, the purposes of the review is, as I say, to modernise the parental leave system to better reflect the realities of modern family life, and to support economic growth by enabling more parents to participate in the workforce, to improve fairness and accessibility, particularly for fathers and lower income families. Now, the scope of the review is wide and it covers all types of parental leave, including a review of maternity leave, paternity leave, shared parental leave and adoption leave. And the government is assessing how these entitlements can be made simpler, more flexible and more financially viable for families. So there was a recent call for evidence and consultation is being carried out with both parents, carers, employers and businesses, as well as advocacy groups and policy experts. The next steps in terms of what comes next, now that the initial call for evidence has concluded, is that the government will set out a roadmap for reform. Now, potential changes that have been suggested to the current parental leave landscape include potentially increasing statutory pay levels. So we'll be having a look at whether the current pay levels adequately support families through the crucial period in their child's early lives. Looking at new day one rights to parental and paternity leave. Simplifying the processes for accessing leave, particularly in relation to shared parental leave where the uptake is low. And looking at measures to encourage greater uptake, particularly by fathers. There has been a suggestion of increasing paid statutory paternity leave to 6 weeks, considering options for providing statutory paid leave to self-employed and non-employed working fathers, as well as simplifying shared parental leave and extending entitlement to parental leaves generally. So if these come into force, what should employers, if anything, be doing now? Well, I think as a first and foremost, keep up to date with the implementation of the new rights under the Employment Rights Bill. We're unlikely to see any proposed reforms as a result of this particular review until at least 2027. But if they do go ahead, they could significantly impact employers' workforce policies and wider planning. So it is worth having a review and starting to take steps to prepare now. And that can involve reviewing your current policies, have a look at your existing parental leave policies and procedures and what you have in place in terms of family-friendly policies. Looking at whether they're clear, are they accessible, are they competitive. You might want to have a think about what the potential impact of any enhancements to statutory pay might look like in terms of your organisational planning. And also thinking about your workforce planning and whether, what impact could those extended parental leave periods have on your staffing models and day-to-day operations. It's worth as well having a look at your current support systems. Are the support systems you have in place for supporting parents who are returning to the workforce as effective as they might be? Are there any barriers that you can identify within your current policies? And you might want to consider looking at leaving rates of new parents, as well as monitoring the use of flexible working applications by working parents. So in terms of what happens next, exact timescales are not quite set in stone. As I say, we anticipate it's unlikely that the results of the review, anything will happen before 2027. But being aware that these are potentially on the horizon and keeping mindful of changes as and when they come into place is always going to be important. Making sure your policies and procedures align with current legislation and address the needs of the workforce, as well as monitoring the progress of this review and keeping up to date so that when potential updates to statutory obligations, if they do come into force, that you are prepared and aware that these are coming. So that brings us to the end of today's session. If you've got any questions, please feel free to enter them into the chat box and we'll do our best to come back to you and respond to those after the webinar. You will get a copy of the slides and access to a recording of today's session. Do feel free to follow us on LinkedIn to keep up to date with details of any further sessions that we have coming up in our Bite-Size series. And it just leaves us to say thank you for joining us today. We hope you found the session useful as an overview, and we hope to see you in the next webinar. Thank you.
Thank you.